In Part 6 of the Civil Procedure Rules, we look at service of documents. Now, before I get into the substance of this part, what is service and why is service important? Service simply means that another person or a company has received the documents in the appropriate way in accordance with the rules. It is important because if you want to follow any particular court procedure, be that for judgment or anything else, you need to ensure that the other party has been served with the relevant documents in the appropriate way. Sometimes personal service is required. This might be, for example, when someone is ordered to attend court to answer questions. They must be personally served with this order because if they fail to attend, they might well be held in contempt of court and sent to prison. Therefore, they need to be served personally. And so there are different rules by which individuals can be served, companies can be served, and indeed whether service is inside or outside the jurisdiction of the United Kingdom. So looking at Part 6, firstly, there are general rules which, as you might expect, states that this section will apply to the service of documents except where any other enactment, practice direction, or any other part of the Civil Procedure Rules makes a different provision, or indeed that the court orders otherwise, because the court is always going to retain that discretion. An important place to start with the interpretation of service is indeed with what days mean what. And so bank holiday is defined, business days are defined as any day except Saturday and Sunday, or a bank holiday, or Good Friday or Christmas Day. So any other day apart from those will be a business day. This is important when you are calculating time frames under service of documents, because documents have to be served within a specific time frame. And this is how you understand that time frame in accordance with business days as against holidays, weekends, and so on. And the claim will include petition and any application made before an action or to commence proceedings, and the claim form, claimant and defendant are to be construed accordingly. And finally, solicitor will be any person who is authorised under the Legal Services Act, which will include barristers who are authorised to conduct litigation. Now, starting out with service of the claim form in the jurisdiction. Now, you will see at the outset that there are a lot of headings which you can look for various sections of service here. So it starts out with the service of the claim form, which is arguably the most important document, and beginning with service of it within the United Kingdom. So you will see that each of these relevant sections are broken down further into the methods of service, who is to serve the claim form, and then detailing personal service and where to serve the claim form, the general provisions, service on a solicitor or within the United Kingdom, service of the claim form where before service the defendant gives an address that they might be served, and service of the claim form where the defendant does not give an address at which the defendant may be served. Now, just as a broad overview, there are various different ways of serving documents. Now, we're talking about service of the claim form initially. Now, service may be done personally, that is physically handing it to the person, if it's done in accordance with Rule 6. And service may also be done by post. It may sometimes be done by fax or electronic communications if it's done within certain rules. And sometimes there may be other ways that the court will authorise service. I've known this to be authorised by WhatsApp before now, because it was such an important and urgent case that it was going to be heard within the next few hours, that service was done by WhatsApp, for example. And finally, how a company may be served. That might be by any part that is detailed within this section or any other methods that are permitted under the Companies Act. So let's take a look in more detail about these methods of service. Looking first of all at personal service in accordance with Rule 6.5. So let's jump to 6.5. Now, for personal service, the first thing that it mentions is where required by another part, enactment, practice direction, or court order, a claim form must be served personally. And in other cases, it may be served personally, unless other rules apply. So, in other words, there are some instances when it must be served personally. And there's another warning here just to flag up that judicial review and Crown proceedings are flagged differently. So you will look up those separately as well. Now, as obvious as it sounds, a claim form is served personally on an individual by leaving it with that individual. In practice, that just means having someone hand it to the person, and this might usually be done by way of a process server. That means a company or a person whose job it is to physically go and hand these documents to someone, and then sign a certificate of service to show and prove that that person has been personally served with those documents. Now, when we come to a company, personal service might be affected by leaving it with a person holding a senior position with the company or corporation. So that's not necessarily any single individual unless it relates specifically to that individual, but that might be, for the example I've given, where an individual is ordered to attend court. Likewise, with a partnership, it may be left with a partner or a person who at the time has control or management of the partnership business at the principal place of business. Now, there are certain cases where the court has said that it can be served to the registered company address. Now, in a 2019 case, the High Court held that under Section 1140 of the Companies Act 2006 permits service on a director of all documents relating to the proceedings against that individual at the address that they have at Companies House. So it's always important to look for recent case law that interprets these rules and how they might be applied. Now, looking at where to serve the claim form, the default position is that it must be served within the jurisdiction and that the claimant must include in the claim form an address at which the defendant may be served. But again, unless the court makes an order otherwise. So as a rule, remember that the court can have the discretion to make an order that it sees fit. Service on a solicitor or within the United Kingdom. The rule of thumb here is to remember that the defendant must usually give in writing the address of the solicitor which the defendant may be served with the claim form. Or such information might be given by the solicitor acting for the defendant, notifying the claimant in writing that they are instructed to accept service on behalf of the defendant. Now, this is important because if the solicitor has written to the claimant about the dispute but not confirmed that they are instructed to accept service of the claim form, then simply serving it on the solicitor is not necessarily sufficient. But all of this can be clarified in the next section, which is where service of the claim form where the defendant does not give an address at which the defendant may be served. And so if the claimant does not wish to effect personal service but there hasn't been an address given, then there is a table here to show exactly how that person or company is supposed to be served. If it's an individual, usual or last known address. So important here, even if it is the last known address but not necessarily the current address, but the defendant has not or refused to give an address for service, then the last known address would be effective service under the rules. So take a few minutes to familiarize yourself with exactly where service should be effected, but in general, if it's an individual, it will be the usual or last known address of that person or person acting in course of business, such as a sole trader. And in the case of corporations and limited liability partnerships or companies, it will usually be the principal office of that partnership or corporation or any place of business of the company that's within the jurisdiction. But take a moment to look through this table to familiarize yourself with those places. But reading on, it is not sufficient for the claimant just to assume that the last known address is still the current address, because the claimant must undertake reasonable steps to ascertain the address of the defendant's current residence or place of business. So if arguments come up about service later on, it will be important for the claimant to be able to show that they've taken such steps, such as making various inquiries to try to determine the current address. Under Part 6.11, service of the claim form may be by a contractually agreed method. This will simply be if there's a contract that gives an address for service of the claim form in the event of any dispute. Speaking about children and protected parties, the claim form must be served firstly on the child's parents or guardian, or if there is no such person, an adult with whom the child resides or whose care they are in. The next important thing in Part 6 with service, deemed service is taken to be the second business day after the completion of the relevant step in Rule 7.51. Now, these steps broadly defined in 7.5 are first class post, delivery of it or leaving it at the relevant place, or personal service, or fax or other electronic method. Again, referring back to Part 6 for what is actually permissible for service, depending on who you are serving it on. And as a catch-all, under 6.15, there is also an alternative method, but you can make an application under this rule, and the court may order service by an alternative method. All the steps that are already taken by the claimant to bring the claim form to the attention of the defendant are sufficient and good service. And as an ultimate catch-all, the court can dispense with service of the claim form entirely. So remembering this fallback position, the court can generally control and manage cases in any way that it sees fit, thinking back to the court's case management powers we discussed in the previous videos. Under the section Notice and Certificate of Service relating to the claim form, now ordinarily the default position will be if you give the court the address for service, then the court is going to serve the claim form. But where the claimant serves the claim form themselves, they must file a certificate of service. This is just a document proving to the court by what means the claim form was served, how and where and when and so on. And this must be filed within 21 days of service of the particulars of claim, unless all the defendants in the proceedings have acknowledged service by that time, in which case it's not necessary. And this is particularly important when it comes to obtaining default judgment, because the claimant cannot obtain judgment in default under Part 12 unless the certificate of service has been filed where the claimant has opted to serve the claim form themselves. So in exam scenarios, if you get this situation where the claimant has opted to serve the claim form themselves but haven't filed the certificate of service, they will not be able to obtain default judgment. So this is just the first video for Part 6, so take some time to digest the information within there, watch it again if necessary, and come back for Part 2.